Lawyers for Kenya's Deputy President William Ruto had wanted judges to throw out the crimes against humanity charges. They claimed the loss of 6 crucial witnesses' testimony left them without a case. But prosecution lawyer Anton Steinberg said enough evidence remained to convict him. Ruto and his co-accused broadcaster Joshua Arap Sang are accused of stoking ethnic tension to unleash an orgy of violence that drove their political opponents from their homes after national elections in 2007.
The prosecution, however, intends to take the chamber at its word and to focus not on the credibility, reliability and cogency of the evidence, but rather on whether the quantum of the evidence, if accepted, may establish the guilt of the accused.
Is that enough?
Asked by presiding judge Chile Ebo Osuji if the quantity of remaining evidence was sufficient, Steinberg said it was.
Your Honours, my submission is yes, it is, unless the quality of the evidence in question, unless the duff outweighs the plums to such an extent that the court will conclude that that witness's evidence is incapable of belief. Obviously, one cannot reach that conclusion without first embarking upon a credibility assessment. But the nature of that credibility assessment, in my respectful submission, is a very limited one. One needs to look at the evidence of that witness taken as a whole and conclude whether, having read that evidence, the court feels that that witness is incapable of belief.
For prosecutors, this week's hearings are a test of whether they can prevail over the lobbying of Kenya and Ruto's high-powered legal team. They were forced to drop charges against Kenyan President Uhuru Kenyatta last year following similar witness withdrawals, which they blamed on witness intimidation. The hearing has become an important test case for the court in The Hague, which, since being set up 13 years ago to end impunity for the gravest international crimes, has handed down just 2 convictions. Susan Mongeli, CCTV.